Although I'm not really persuaded, but I must temper justice with mercy. The court is moved by chapter 23, verse 23 of Matthew, in the book of Matthew, to the fact that, "Who unto you, scribes and Pharisees, hypocrites, for you pay tithes of mint and anise and cumin, and has omitted the weightier matter of the law, judgment, mercy, and faith. This you ought to have done." Particularly, and must notice the word in Matthew 23 and verse 23, the word mercy. Our Lord himself is merciful. No matter what we do, he is a merciful God. It is on that note that the court will follow this above admonition of Jesus Christ in the above passage and show mercy to the convicts. In addition, the death penalty globally is now being frowned upon by the international community. Consequently, and in the interest of justice, I hereby sentence the convicts to life imprisonment for the said counts 1, 4, 5, and 6 instead of death sentence. Life is sacred to God. With respect to count 3, he is hereby sentenced to 20 years imprisonment without no option or fine. For count 7, he is sentenced to 5 years imprisonment without no option or fine. To extend the mercy, I hereby order that the sentence shall run concurrently. And due to the nature of the offences that borders on terrorism and the attitude, violent nature of the defendants that I have taken judicial notice. The last adjourned date, he was so unruly and expressed violence, even was about to beat the security officers there. This morning, he repeated same.
Felony later became 15 counts amended charge on terrorism and treasonable felony. The Nnamdi Kanu challenged these charges, and the court struck out 8 out of the 15 counts, leaving 7 counts. Still, he wasn't very happy with the remaining counts. He insisted that the court should have struck out the entire charge against him. So he went to the Court of Appeal, and the Court of Appeal graciously granted Mr. Kanu his relief and struck out the entire charge and asked that he should be sent home. That due to Nigeria, that in fact made the whole process vain. The federal government informed and prayed the court to stay execution of that judgment. So they went up to the Court of Appeal, Supreme Court, I beg your pardon, and the Apex Court did not, in fact, agree with the Court of Appeal. The Apex Court has said that the fact that Mr. Kanu was extraordinarily renditioned or the manner in which he was brought back to the country was in violation of the Kenyan extradition laws. He should have come by way of enforcement of his fundamental human rights, stating that his rights was violated. But that does not mean that the remaining 7 counts against him, he would not answer for those charges. So the court ordered that he goes back to the Federal High Court to answer to the remaining 7 count charges against him. So now we all came back to the Federal High Court for the commencement of the trial in the 7 count charge. But during that process, success was not really achieved because it came from one application to another. As a matter of fact, Justice Binta Anyanko ruled on over 22 applications of motions. First, brought by the prosecution, and also most of them brought by Mr. Kanu, alleging his ill treatment at the facility of the DSS, how he didn't have access to lawyers, how his health was deteriorating, how he was kept in a cubicle, a 2-by-2 cell with no light. So basically, he was asking the court to intervene, and also how he didn't have enough time to consult with his lawyers. According to him, anytime his lawyers came to the facility of the DSS to talk to him and strategize for the trial, they eavesdrop on their conversation. But the time they eavesdrop on their conversation, when they come to court, their strategy will not work because the DSL just being there. It got to a point where Mr. Kanu feel that he could get justice if the case is being decided by her. So my
That's our senior reporter who has been monitoring the court's process, the judgment, where court has gone on recess and is expected to reconvene at 3:50 p.m. for judgment on Nnamdi Kanu's case. It's been a busy day in court. Celestine, I'm hoping you can hear me at the moment. Can you continue what you were saying?
Okay, so as I mentioned, when he came before Justice Montishon, the first thing Mr. Kanu did was to apologize to the courts. He apologized to the courts. He also apologized for making Mr. Montishon to ensure that they start on a very clean slate and clean note. So the judge said that whatever happened in his brother courts is none of his business. He will decide the case as it all should be, without sentiment of fear or favor, and to be done in accordance with the law. So the case commenced, the prosecution opened their case, and they started calling witnesses. The prosecution called 5 witnesses who came to tender evidences, and most of the evidence were video evidences, which was played in court on how Mr. Kanu called for violence, inciting violence, acts during the NSAS protest, and also during calling for sit at home, and also calling that bombs be made by engineering graduates and chemists graduates. So all this evidence that the operatives of the DSS, they all gave evidences which were tendered and accepted in court. But his lawyers said that
Supreme Court here. Hold on a second. I said, hold on. May you please, your lordship? Please. May I refer your lordship to section 266 of ABJA? It's not of law. What you're doing is not law. Please. You don't know the law. Please. Show me. Please. I said, show me. When you have the right to go to my right to hand address. Show me. What the Constitution says. Show me.
Well, I will rise and come back.
You cannot show me.
Can you please take him out? I'll come back. I rise. I'll come back in 5 minutes.
All right, Celestine, I'm not letting you go, but just before we continue the conversation of what happened in the court today,